I'm just testing the audio here, and we'll get started in a couple minutes. All right, I think we're going to get started. My name is Rachel Clattenburg, and this is a presentation about the federal FOIA law, the Freedom of Information Act. If you are looking for information on state public records, you should look online. This is just going to be about the federal act. Let me just quickly introduce myself. My name is Rachel Clattenburg. I work at the Public Citizen Litigation Group. We've been litigating FOIA cases for over 40 years, but we also deal with a number of other issues such as consumer rights, regulations, access to the courts, administrative law, First Amendment, and then of course open government, which is what we're doing today. Public Citizen, we are operate as a law firm within Public Citizen. We accept no government or corporate money. We just rely on foundation grants and donations. Here's some quick contact information. If you are looking for litigation, FOIA litigation examples, we have a case page at citizen.org/FOIA, and you can see all of our FOIA cases and the filings in those cases. And we also have a list of some of the other FOIA resources. And my contact info is here. You can send any questions you have about FOIA to foia@citizen.org or to me, rclattenburg@citizen.org. We are always happy to consider any kind of FOIA litigation requests, so you can also send those there. All right, let's get started. FOIA fundamentals. FOIA is a powerful law based on 4 principles that underlie it. First of all, is the presumption in favor of public access to government information. The burden is on the government to justify its withholdings. It's presumed that the public has access to information. Second, it's a very accessible tool. You don't have to be an attorney. Anyone can use it. It's simple, and I hopefully will be showing you that today. Third is there are clearly defined categories of information that the government can withhold. These are the 9 exemptions. If it's not in one of those exemptions, the government can't withhold it, and again, the government has the burden of justifying that the information falls within one of those 9 exemptions. And fourth is the judicial review provision, which gives the law its teeth, and the courts perform an independent determination of whether the information falls within the exemptions. This is really all you have to know about filing a FOIA request. It's just a letter describing what you want to get from the government. They have to be agency records, and you need to address fees. So that's really all there is to it. I'm going to go a little more into depth, but it's very easy. You should use it. It can be a very useful tool. The first part of my presentation is going to focus on the mechanics of filing FOIA requests, some information and strategies I have that I think will help you, or I hope will help you get the information you want more easily. And in the second part, I'm going to talk more about what you can get under FOIA, the types of information you can expect to get that are unredacted, and strategies for getting those. All right, so let's start off with some of the basics here. Any person can request agency records, and you can request them from federal agencies. FOIA does not apply to the courts, and it does not apply to Congress. And agency records are as compared to personal records. So for example, an agency official's appointment calendar, even if that appointment calendar contains personal appointments, if that calendar is used by the official and her staff for scheduling purposes or for agency business, that would still be an agency record. And there was a question submitted in advance of this presentation about whether emails on a private server are subject to FOIA. It does depend, but if it's an agency official using a private email account to conduct agency business, the DC Circuit held that simply using a private email account to run an agency you're not shielded by FOIA. So yes, just that is not a way to avoid FOIA. If you have a private email account, that's not enough. Those can still be subject to FOIA. That case is Competitive Enterprise Institute versus OSTP, and it's a DC Circuit case from last summer. This is a brief overview of how FOIA works, or how it's supposed to work. First up here, you send in a proper request, which I'll go over, to a federal agency. They will send you some sort of acknowledgement email or letter. They're supposed to take no more than 20 working days, although they can ask for 10 additional days in unusual circumstances. If they miss that deadline, you can sue, because that's called constructive denial, or you can wait, and then eventually they're supposed to issue a determination, and you can appeal that determination. And again, their appeal decision is supposed to take no longer than 20 working days. If they miss that deadline, you can sue, or if they issue determination on the appeal, you can also sue. So that's a brief overview of how this works. Now let's get into drafting the request. You need to, first of all, reasonably describe the records that you want, and I recommend being as narrow and targeted as you can. You can always come back for more records if you find out that what you requested wasn't enough, and so I just recommend being more narrow. You can't ask questions in the FOIA request. They don't have to answer any questions. You need to actually describe agency records that exist. You can ask them to create records. Sometimes agencies do create some sort of spreadsheet or table in response, but they're not required to. And again, as I said, I recommend being more specific and erring on the side of narrow. And your request must be in writing. So one thing I think is important about getting information through FOIA is really figuring out what types of records an agency has, so you can figure out what to ask for. Everyone thinks of emails, and those get requested a lot, but there are other types of records, and they might actually be easier to get, and they might actually have all the information you want. Emails are often, as I'll talk about, if they're in emails between agency officials, agency staff, they're often exempt under Exemption 5. So how can you think about what it is you want and what to ask for, and what the agency might have in terms of records? So when you're brainstorming this, you should be aware that agencies have FOIA logs, and these vary by agency as to how up to date they are, but you can see this is NIH. It's pretty up to date. It lists the request, the organization that requested it, and the types of records requested. And this is useful in trying to figure out what types of records are out there, because some requesters know more and have requested certain information. This is also just interesting. You can see, so for example, like a research institution is asking for copies of grants. And you can see a corporation asking for records about other corporations. Corporations are big users of FOIA for that purpose. And then you can see the individual asking for all emails, which is, as I said, very common. This is Customs and Border Protections FOIA log. A lot of it is being redacted as or withheld under the privacy exemption, which is B6, but it's also just interesting, I thought, for you to see that. Another good resource is muckrock.com. You can, first of all, submit FOIA requests through there for a small fee, but I also recommend looking at their database of filed FOIA requests and also responses they've gotten. It's just a great way to generate ideas for how to request stuff and what types of records you can request. This is what their website looks like if you go to that link I just had there. Here I have sorted it, filtered it by completed requests, so ones that the agencies have responded to already, and United States of America, because I'm looking at federal ones. Muckrock also has a lot of state and local level public records requests. But really interesting, if you click on these, you can see the request and any of the agency's responses. It could be very helpful in you trying to think up how to draft your request. Another good option is just keep your eyes out for news articles on what types of records these agencies are producing. This is, for example, one that we requested and ultimately sued over, and it came from this news article where this corporation provided a memo to Bloomberg News on the condition that Bloomberg News not publish the document and that the news organization drop an effort to obtain it through a public records request. So we asked for that memo just based off of this news article. And also for the news articles, you can in your request refer to documents that are mentioned in news articles. That's a good way to narrow it. And speaking of narrowing, again, as I've said before, I really think specific is better, and a way to do that is you can narrow always by time, so a certain time frame. You can suggest keywords that they search for or people. Those are just 3 easy ways to narrow your request. The agency can deny requests as being overbroad, and these are 2 examples from cases where the courts have held that the request was too broad. One was a page-by-page search through the 84,000 cubic feet of documents. Doesn't seem ridiculous to say that's too broad. And another one was all records about the requester from all of the IRS's offices. But I also want to mention that you will probably have the FOIA officer at the agency. It's very common that they'll call and say, hey, your request is too broad. You need to narrow it. You need to name specific people, for instance. You don't have to agree with that. Like, just because they say it's overbroad doesn't mean it's overbroad. And if you disagree, you can tell them, I think this search is reasonable and it's a reasonable request. It's reasonably narrow. If you think it's overbroad, please deny our request on that grounds and issue us a denial letter. So you don't have, just because they call and tell you, they say that your request is too broad, which I get that call quite often. You don't have to, they're not always right about that. You can challenge that. All right, let's go on to fees. Agencies are permitted to assess fees for FOIA requests. There are 3 categories of requesters: commercial, news media, and all other. And there are 3 types of fees they can assess: search fees, review fees, and duplication fees. And you can see here, based on this chart, some are applied. Only commercial has to pay all of those. And there are some, less than 100 pages for news media or all other are free, for example. This is examples of some of the agency's regulations on fees. They do vary. So you can look those up if you're curious what the rates are. And I just thought this was kind of humorous. This is an actual example. The DoD's response to a Muckrock News FOIA request, where DoD said that the search costs and the response would cost something like 15, it would be 15 million labor hours at an estimated cost of 660 million, which I think most people would see as just a way to perhaps deter this request. So there are ways to get around the fees if you qualify. One is the public interest waiver request. So you can ask for this in your FOIA request. It has to be in the public interest, not primarily in the commercial interest of the requester. There are 6 factors you should address and support each of them in your FOIA request. And by support, I mean you should point to specific examples of how your organization is disseminating in the news the information or how it's in the public interest. There's also, you can ask to be categorized as a representative of the news media. And again, there are factors you need to set out and support. But you don't have to do that. You can also just, if you don't qualify for either of those, you can say, I'm willing to pay up to a certain dollar amount and list that in your request. Or you can say, if there are fees, please inform me before you incur them. Because again, you get the first 100 pages in the first 2 hours for free. So if you're only asking for a small number of documents, you may not be assessed any fees anyway. I just want to make 2 quick notes about fees. First, there is a provision in FOIA that the agency may not assess search fees, or in the case of a media requester, they can't assess duplication fees if the agency misses its 20 working day or 30 working day deadlines. And this is the citation for that in the FOIA statute, and you should just be aware of that. The second is that if you have any plans to litigate a denial of a fee waiver or fee request category, make sure you support your request for that waiver or category sufficiently, because the court reviews the record that was before the agency. Okay, and the third step here for drafting your request is figuring out where to submit the request. And I actually don't find this that easy. This website is helpful. It'll point you to you can go there and it will show you the different agencies, and you can click on them and then it'll give you the FOIA contact info. I highly recommend whatever they have listed there, you also go to the agency's website, because they are not always perfectly consistent. And sometimes there's an easier way to do it from the agency's actual website than from this central site that's supposed to collect everything about where you can submit FOIA requests. There are online portals for submitting FOIA requests. Some of them use this centralized one called FOIA Online, but a number of them have their own, which is a little bit annoying because they're all slightly different. My preferred method of doing it is just PDFing a letter and then emailing it, but some agencies have stopped giving out a FOIA email address, and sometimes it's hard to track down. But if they have that as an option, I always do that. I think it's much easier than these online portals, but it's whatever works for you. And also just make sure you're following whatever the agency's FOIA regulations are for how to submit a request. And in terms of the U.S. Citizenship and Immigration Services, they have a handy table. This isn't the whole thing. I just took a screenshot of part of it. And it lists the type of record that you're looking for, and then which sub-agency you should be submitting that to. So that looks helpful. And also, when it comes to immigration records, you should be aware of the Privacy Act. If you're asking for records, someone's immigration records, or any records that are retrievable by a person's name or identifier, you are asking for records under the Privacy Act, and you will need to have a certification and verification of identity form. The website will have this for you. We'll tell you how to do it, but you should just be aware of that. So this is USCIS's information about that, and it tells you how, if you want that, what you have to submit. And they also have a form available online. But just be aware of that if you're asking for someone's immigration records or any records about a particular person. All right, this is a quick overview of the process so far. You're going to research to figure out what kind of records there are, try to best draft your request. You'll also make sure the records are not already publicly available so you don't waste your time. You'll reasonably describe them. You'll be as specific as possible. Ask for a fee waiver or a fee category, or set some sort of limit as to how much you're willing to pay, or ask them to tell you before they charge you for anything. Check out the agency's rule. If there's a Privacy Act records that you're asking for, make sure you have submitted the proper waiver or certification, and then you'll figure out where to submit it and submit it. The agency will send you some sort of acknowledgement, and eventually, hopefully, you will get an agency determination. I just want to quickly say that an agency determination under the law doesn't have to be all the responsive records. It just has to set out the scope of what the agency will produce, the exemptions they will be applying, and give you notice of appeal rights. This is a sample of a determination. And once you have your determination, you can appeal. You should appeal in full to make sure that you're not waiving any arguments if you end up deciding to litigate. Agencies have different deadlines. You should check that out. Make sure you don't miss them. Some are as short as 30 days. As of last summer, with the new amended FOIA Act, the deadline for all agencies is 90 days, but that only applies to requests that were submitted after June 30th of last year. So if you have any requests that are in the pipeline from before then, it's a different appeal deadline. If you submit one now, you'll get a 90-day deadline to appeal. All right, let's move on to the second part about the types of information you can get from FOIA. And I'm just going to run through a bunch of examples because I think it's really helpful to realize that you can get a lot more than just emails, even though that's what you're going to want. As I said before, emails that are within an agency or between agencies, you can ask for them, you'll get some of them, and a lot of them will be redacted. So the more you can think outside of the box of emails, I think the more successful you'll be in getting a FOIA response that isn't heavily redacted. Not always, but it's just good to know what types of information you can get. So these are some examples from some of the groups in Public Citizen, for instance, and some other places that have successfully used FOIA for their own work. And these have not gone through litigation, so this was just stuff that's released. Research protocols from NIH. Consent forms for studies. Policy memos. FDA adverse event reports for drugs. They have a whole database, and you can request the more specific report for one of the ones listed in the database. FDA inspection reports of American Red Cross blood banks. Contracts. This one is taken from an article. I thought it was just sort of amusing. It was a contract for the TSA iPad that randomly generated an arrow either going left or right to tell you which line to go in for security, and it was something like 1.4 million, or ended up being, I don't know, several hundred thousand once you took out some parts of that, but it was an amazing amount. You can get consumer complaints. This is one about airlines and the comfort of the seats, and they said that the seat felt like it barely had a cushion. This is another consumer complaint about FCC complaints regarding the Colin Kaepernick and/or San Francisco 49ers. It's just all over. And if you pay attention in the news, they often don't say FOIA, but they'll say something like public records request, open records request. And all these articles that I have here, all based on information that came through FOIA. And again, more articles relying on FOIA. So I want to get back to what I was been kind of saying the whole time was, this is the type of information you're going to want. You're going to want emails between agency officials. You're going to want drafts of proposed guidance. How did they come up with this guidance? How did they come up with this draft? What changes did they make to this rule before it was finalized? Draft environmental assessments, draft studies, communications and memos within the agency on any of these subjects. And when you sit down to ask for that stuff, I think just pause for a second, because you should realize, while you can definitely request that stuff, just be prepared that you're going to get a lot of stuff that looks like this, where you get an email where you can maybe see everybody it was to and from, and you can maybe see the signature line, but a lot of Exemption 5. If this is what you need, ask for it. You can definitely ask for emails, but is there another way you can get what you want? So I'm going to quickly go over Exemption 5 because it is applied a lot, and if there's a way you can get around it, you're more likely to get the information you want. So Exemption 5 applies to inter and intra-agency memos that would be privileged in litigation with the agency. So anything that would normally be privileged in civil discovery. There are a number of privileges. The ones you're most likely to see are the deliberative process privilege, which applies to information that is both deliberative and pre-decisional, and then the attorney-client privilege and the attorney work product privilege. So this stuff that's covered by Exemption 5, recommendations and deliberations that are part of the process by which the agency decisions and policies are formed. So it's quite broad, and it's often the type of information you want. And my last point here is just that even though it says inter and intra-agency, sometimes emails and memos between agency and outside entities who are treated as consultants to the agency are also covered by Exemption 5 under the consultant corollary, if they're acting as agency employees or in the interests of the agency and not in furthering their own interests. So the policy behind this deliberative process privilege, which is the one that I see invoked the most under Exemption 5 and you're more likely to encounter, is that this fear that if you release this information, it would stifle the honest and frank communication with the agency. And this is a quote from a case that is often referred to, and it's just that you don't want the agency to have to operate as if it was in a fishbowl, with everybody being able to see all the decision-making process. So the type of information that Exemption 5 applies to are advisory opinions, recommendations, deliberations, papers that reflect agencies' group thinking and working out policy, emails between agency employees, briefing materials summarizing issues and advising superiors. So instead of asking for these sort of internal communications, one thing you can do is ask for communications between outside entities and the government agencies, because those do not fall within Exemption 5. Sometimes Exemption 4 comes up, but I recommend you see if you can get this information by asking for information that would have been exchanged between someone outside the government and then the government. The next exemption I just want to quickly cover with you is Exemption 6, which is the personal privacy exemption. Especially if you're asking for something like immigration records, you're likely to run into this. This is a photo that has been redacted under Exemption 6. And as you can see, they redact the heads. I just think that's kind of eerie looking, but that's how they do it. Exemption 6 is a balancing test. So it's a balance between the public interest and the privacy interest in disclosure. And the public interest for purposes of Exemption 6 is the extent to which disclosure lets the public know what the government is up to. And if that outweighs the privacy interest, then they release it. Otherwise, they don't release it. Exemption 6 is often used to withhold names, addresses, telephone numbers, email addresses, criminal history rap sheets, birth dates, social security numbers, passport information, identities of crime victims. There's a Supreme Court case dealing with Exemption 6 in the immigration context, and that was the court upheld the use of Exemption 6 to withhold identifying information in reports of interviews that the State Department employees conducted with persons who had been voluntarily returned to Haiti. And the case name is there. But Exemption 6 has not applied, and they have released information such as names of those who voluntarily submitted comments to the government on a policy, addresses of farmers who received federal subsidies, names of those who violated federal grazing laws, and most federal employees' names, titles, grades, salaries, and qualifications, although that depends, and I think the higher up a federal employee is, the more likely they are to say it's not exempt under Exemption 6. So that is Exemption 6. You should just be aware of that. And one more note is that we've been seeing more frequently is agencies redacting information as non-responsive, and non-responsive is not an exemption. And so I just want you to be aware of that. They do this. It is not an exemption, and the DC Circuit, in a case that one of the attorneys in our group brought, held that that is not an exemption under FOIA. All right, let's get to the deadlines. As I said before, they have 20 working days to issue their determination, and then they can get a 10-day extension for unusual circumstances. They can also toll under certain circumstances. However, the reality is that it is extremely unlikely you're going to get them that fast, and it is a very slow response time. The deadlines and the timing are going to probably be your most frustrating part of filing a FOIA request. It's just very frustrating. There was a question about what to do in this circumstance, and I'll give you some strategies, because what you're going to end up with is oftentimes as you file a FOIA request and you just don't hear anything, or they tell you they don't know. They're working on it, and what do? You don't have any answers, and you would like your records. So just to show you how common this is, these are some humorous headlines from TechDirt that are based on real FOIA requests. The State Department has taken over 3 years on a FOIA request about how long it takes to process FOIA requests, and also the CIA took 3 years to reject FOIA requests for criteria for rejecting FOIA requests. And at the bottom here, I wanna just give you this warning though. I think it's tempting to think that when you don't get a response and they are taking forever to respond, it's tempting to think that they are hiding information, but it's really just a very inefficient process, and I think the vast majority of the time they're just overwhelmed with FOIA requests, and it's just a very inefficient process, and it's not obstruction. So what can you do? As I said before, narrow your request as much as you can when you write it. Fewer documents, you're more likely to get a faster response. You can, by law, ask for an estimated date of completion, which they're required to provide for you. And I recommend just politely checking up with your FOIA officer every few weeks, every couple weeks, just to make sure they know, you're keeping track of this, what's going on. But another option is if you can try to negotiate with the agency by asking if you can modify the scope of your request. Would that speed it up? You can ask them to produce documents on a rolling basis rather than once they've processed everything, just as they process it, to have them release it. You can negotiate a priority search, so ask them to search for, just these officials first, and then let you look at those documents and see if you want more, or maybe that will help you modify the scope and narrow it. You can also ask them if they would be willing to do an initial search of just a small number of records to see what that produces, to see if this is the type of, if you want to change your request at all or modify the scope, if this is producing the records you want. So those are some ideas for what you can do if they just are delaying. There's also, of course, the option of litigation. Before you can sue, you have to exhaust your administrative remedies, but failure of the agency to meet its deadline is considered constructive exhaustion. One note on that: if they miss their deadline for sending you their final determination on the request, and so it's like, they don't send you anything for 40 days or 50 days. If they then send you a final determination, you do have to appeal before you can sue, even though they sent you it late. So if you've administratively exhausted your remedies, you can sue. You can sue in DC, you can sue where the records are, you can sue where you are or where your principal place of business is. Most of the case law in FOIA comes out of the DC circuit, and a lot of the other circuits look to DC circuit for law on FOIA because it just has so much law on it. You should also be aware of the Open America stay. An agency can request that the court retain jurisdiction or stay the case while giving the agency additional time to complete its processing of the request if the agency can show exceptional circumstances exist and that the agency is exercising due diligence in responding to the request. So if you sue on a request very quickly after the expiration of the 20 days, it would not be shocking if the agency filed a request for an Open America stay, because they will probably just say to the court, this was an unreasonable amount of time. We are deluged with requests and we need more time, and the court may well grant that. So in that case, you're paying a filing fee just to have more delay. So you want to look into the Open America stay stuff before you sue. It also is not, litigation isn't always a great answer for delay either. It's expensive. You have the $400 filing fee, and there's delay built into the litigation as well. You have 30 days for the agency to answer, but they often get a 30-day extension. And then there's the motions practice, and the whole thing takes a long time too. FOIA litigation is a little different because the agency has the burden of proof. Often they're the ones to file the motion for summary judgment first, and then the plaintiff goes second. All right, and just to finish up, these are some great resources both for drafting and in general. The Department of Justice has a guide on FOIA. It's very useful for the law on FOIA, exemptions, also the litigation. It's extensive. It's on their website. I've mentioned Muckrock. There's FOIA Project, FOIA Mapper, FOIA.gov. The Reporters Committee also has a useful guide. And then the FOIA logs, which I mentioned to you that each agency has. And I do not see any questions that were posted. And I think we are pretty much done. If you have any questions, again, feel free to email me or foia@citizen.org, or me, which is R. Clattenburg, at citizen.org. And thanks so much for joining.